My prediction is that this lawsuit is going to fail, but not for legal reasons, for social reasons. Viva Frei Montreal litigator turned YouTuber, another day in lockdown, another constitutional lawsuit. In this lawsuit, the plaintiff is Pamela Geller suing Bill De Blasio and Dermot Shee for First and 14th Amendment violations. To start this vlog off with my full disclosure parentheses, I don't really know who Pamela Geller is. I know what I've heard about her in the news, I know she has a website called PamelaGeller.com, but I really don't know the first thing about her. Knowing what I think I've heard about her in the media, I can only predict that Wikipedia is going to define her as right-wing. For right or for wrong, and you can fault me for not doing this, I'm not getting into who Pamela Geller is. It doesn't change anything as relates to the substance of her lawsuit. For those of you who have been following my channel for a long enough time, you'll know that I often say that I think everyone would benefit from practicing law for at least 1 year of their lives. Why? Because I think people would learn valuable lessons about critical thought and techniques of argument. One of the most fundamental in law is that you can be a good person with a bad argument, and you can be a bad person with a good argument. Which means that at the end of the day, it doesn't matter who the person is that is making the argument, you can only go after the substance of the argument itself. So for the purposes of this vlog, and if you're watching Pamela Geller, please don't be offended. I don't care who Pamela Geller is. I don't care what her belief system is. I don't care how controversial of a public figure she is. None of that is relevant for the purposes of this lawsuit, and none of that is going to undermine or strengthen the arguments raised in this lawsuit. So with that said, let's read the lawsuit. In the United States District Court for the Southern District of New York, Pamela Geller, plaintiff, versus Bill De Blasio, individually and in his official capacity as mayor, City of New York, and Dermot Shee, individually and in his official capacity as the police commissioner, City of New York, defendants. Complaint 42 USC 1983. We've gone over it before in previous vlogs, but let's just refresh our memory. What is 42 USC 1983? Legal Information Institute, open access to law since 1992. 42 U.S. Code 1983, civil action for deprivation of rights. Every person who, under color of any statute, ordinance, regulation, custom, or usage of any state or territory or the District of Columbia, subjects or causes to be subjected any citizen of the United States or other person within the jurisdiction thereof to the deprivation of any rights, privileges, or immunities secured by the Constitution and laws shall be liable to the party injured in an action at law, suit in equity, or other proper proceeding for redress. The Coles Notes version: if your rights get violated, you get to sue. Plaintiff Pamela Geller, by and through undersigned counsel, brings this complaint against the above-named defendants, their employees, agents, and successors in office, and in support thereof alleges the following upon information and belief. This case seeks to protect and vindicate fundamental liberties that citizens of the United States enjoy, free from government interference. These laws are not conferred or granted by government to then be rescinded at the will and whims of government officials. These God-given liberties are possessed by the people, and they are guaranteed against government interference by the United States Constitution, which is the supreme law of the land. First among these liberties is the right to peacefully protest government officials through the freedom of speech and the right to peaceably assemble, guaranteed by the First Amendment. The right to freedom of speech is not a right to catharsis. It is a right to meaningfully protest and assemble in order to change public policy. The most effective way to exercise this right is to organize and participate in a large public protest. Defendants, through the adoption and enforcement of executive edicts, have suspended this fundamental right in the City of New York. I have grown accustomed to the difference in drafting of lawsuits in the United States versus Quebec. In Quebec, drafting is much drier, it's much less lofty, it's much less literary. I've done vlogs on a ton of lawsuits filed in the United States, and they all sort of are drafted much like books. I'm still getting used to it. In some cases, it's done better than others. For example, the Tulsi Gabbard Google lawsuit was not among the best things I've ever read. But as far as American constitutional lawsuits go, I kind of like the way this one reads. Short, concise, impactful, to the point, but the next paragraph is the one that really gets me. John Adams once warned that, quote, liberty once lost is lost forever. All tyranny needs to gain a foothold is for the people of good conscience to remain silent. Through this complaint, Plaintiff Geller challenges defendant's suspension of the First Amendment. There is no justification, pandemic or otherwise, for a government official to revoke this fundamental right of the people. Regardless of how you might feel about Pamela Geller personally, this is one powerful paragraph. Freedom is fought for and gained by the inch and lost by the mile. And once you start losing your freedoms, it's not long before you start getting arrested for paddleboarding in the ocean or going to jail for operating your business. Accordingly, this case seeks to protect and vindicate fundamental constitutional rights. It is a civil rights action brought under the First and 14th Amendments to the United States Constitution and 42 U.S.C. 1983, challenging defendants' restrictions on plaintiff's right to engage in peaceful protest and protected speech in public forums in the City of New York. Alright, and very quickly, the relevant portions of the First and 14th Amendments of the Constitution read as follows. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of the people peaceably to assemble and to petition the government for a redress of grievances. Section 1 of the 14th Amendment. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. This is the constitutional basis of the lawsuit. Plaintiff seeks a declaration that defendants violated her clearly established constitutional right as set forth in this complaint. A declaration that defendants' First Amendment restriction violates the United States Constitution and 42 U.S.C. 1983 as set forth in this complaint. A preliminary and permanent injunction enjoining the enforcement of defendants' First Amendment restrictions as set forth in this complaint, and nominal damages for the past loss of plaintiff's constitutional rights. Plaintiff also seeks an award of reasonable costs of litigation, including attorney's fees and expenses pursuant to 42 U.S.C. 1988 and other applicable law. We have gone over injunctions at length in previous vlogs. An injunction is an order of the court enjoining someone to do or to not do something. Preliminary injunctions remain in effect until the hearing on the merits or the trial, and they're sort of there to reestablish the rights of the parties and preserve their rights pending the hearing on the merits. The permanent injunction basically is just the final judgment of the court. Jurisdiction and venue is boring. We're going to skip over it. Let's get to the plaintiff. Plaintiff Pamela Geller is an adult citizen of the United States and a resident of the city of New York. Plaintiff Geller is a champion of the First Amendment. She is the president of the American Freedom Defense Initiative, a non-profit organization that defends the right to freedom of speech. She is a published author, a conservative blogger, and a political activist. Plaintiff Geller was the organizer of the successful public protest of the Ground Zero mosque construction in Lower Manhattan. She has also successfully challenged government restrictions on free speech in New York. But for defendants' suspension of First Amendment activity within the city as set forth in this complaint, Plaintiff Geller would organize and participate in a public protest of defendant De Blasio's draconian restrictions on liberty he has imposed during this My Sharona Cyrus Pashmendrick. Now, for those of you who are new to the channel and have no idea what I'm saying when I say the My Sharona Cyrus Shmendrick, for a bit of time, YouTube was just systematically demonetizing videos if you even said certain words. Apparently, the policy has in fact been reversed, and you are allowed saying these words now without your videos being systematically demonetized, but I've just fallen in love with my nickname for the subject, the My Sharona Cyrus. In fact, I may move on from that nickname, and anytime I want to refer to it, just flash this. Then we have the description of the defendants. We'll go over it quickly just for the sake of it. Defendant Bill De Blasio is the mayor of New York City. As the city mayor, defendant De Blasio is responsible for adopting, creating, and enforcing the policies and practices of the city, including the challenged policy and practice of suspending the First Amendment within the city as set forth in this complaint. Defendant Dermot Shee is the New York City Police Commissioner. As the city police commissioner, defendant Shee is responsible for enforcing the policies and practices of the city, including the challenged policy and practice of suspending the First Amendment within the city as set forth in this complaint. And this is where the lawsuit gets interesting. The lawsuit itself is very simple. It is contesting the validity, the constitutionality of certain executive orders. And it was only through the exercise of trying to find the actual impugned executive order that I came across so many executive orders, it's just going to blow your mind. On or about May 4, 2020, defendant De Blasio issued Emergency Executive Order number 111, which took effect immediately and will remain in effect for 5 days unless it is terminated or modified at an earlier date. Executive Order number 111 is, in relevant part, a continuation of various provisions set forth in prior executive orders, including the provision that, quote, any non-essential gatherings of individuals of any size for any reason shall be cancelled or postponed, or words to that effect. The purpose and effect of the executive orders is to, quote, shut down most of the city due to defendants' belief that these restrictions will help stop the spread of... During a recent press conference, defendants publicly and officially announced that the shutdown required in the executive orders includes the suspension of the right to publicly protest in the city, thereby officially announcing the challenged First Amendment restriction. The factual basis of the lawsuit is no more complicated than that. Given the state of emergency, De Blasio issued executive orders which basically prohibited any gatherings of a certain amount of people or more. And not that I would doubt or deny the description of the executive order as it is provided for in this lawsuit, I did want to read the executive order itself, so I went to look for executive order number 111. And this is what I found. Whereas on March 7, 2020, New York State Governor Andrew Cuomo declared a state disaster emergency for the entire state of New York to address the threat that poses to the health and welfare of New York residents and visitors. And the preambles go on. You can pause and read them for yourself if you want, but let's just get to Section 1. Section 1. I hereby direct that Sections 1, 2, 3, 4, 5, 6, and 7 of the Emergency Executive Order Number 110, dated April 29, 2020, are extended for 5 days. I will save you the pain and suffering. Each one of these executive orders refers to a prior executive order all the way back to the original Executive Order 99, which contains the impugned provision. What does Executive Order 99 say? Let's read it together. Whereas on March 7, 2020, New York State Governor Andrew Cuomo declared a state disaster emergency for the entire state of New York to address the threat that poses to the health and welfare of New York residents and visitors. Whereas Emergency Executive Order Number 98, issued March 12, 2020, contains a declaration of state of emergency in the city of New York due to the threat posed by to the health and welfare of city residents, and such declaration remains in effect for a period not to exceed 30 days or until rescinded, whichever occurs first. Whereas the reduction of opportunities for the person-to-person transmission of in meetings and other gatherings is necessary to combat the spread of this disease, and it goes on. But alas, the provision that concerns us is found at Section 1. In order to avoid the mass congregation of people in public places and to reduce the opportunity for the spread of any large gathering or event for which attendance is anticipated to be in excess of 500 people shall be cancelled or postponed. Hallelujah, we finally found the provision. Now, how does this restriction in the executive order impact Pamela Geller? Let's get back to the lawsuit to find out. Paragraph 23. Despite suspending First Amendment activity within the city pursuant to the First Amendment restriction, defendant De Blasio has implemented an open streets initiative whereby certain streets are open to pedestrians and cyclists. However, these same streets remain closed for First Amendment protest activity, even if the protesters maintain proper social distancing. But for the First Amendment restriction, plaintiff would organize and participate in a public protest of defendant De Blasio's policies, including the draconian restriction he has imposed upon fundamental liberties during the But for the First Amendment restriction, plaintiff would organize and participate in a public protest, maintaining proper social distancing on the city streets that have opened pursuant to defendant De Blasio's Open Streets initiative. Through the First Amendment restriction, defendant De Blasio seeks to silence such opposition to his policies so that he can retain his political power over the city and its residents. Consequently, the First Amendment restriction operates to suppress those viewpoints that oppose efforts by government officials, which specifically includes defendant De Blasio's efforts to control people's lives and restrict their liberty during the My Sharona Cyrus Transfendrick, a viewpoint shared by Plaintiff Geller. A large public protest is the most effective way for plaintiff and others who oppose defendant De Blasio's policies to express and show their opposition. Such protests also generate a great deal of media attention, particularly in New York City. There are no reasonable or effective alternatives for plaintiff and others to express their opposition to defendant De Blasio and his policies. The specific purpose of this allegation is to counter an argument that Geller knows is coming. Defendants are undoubtedly going to say, you still have your freedom of speech, you still have your freedom of assembly under certain restrictions. To the extent that you still have those rights subject to certain restrictions, those rights have not been violated. Geller is anticipating that argument and building the argument that if there is a sufficient degree of interference in the free exercise of those constitutional rights, there is in fact a violation of those constitutional rights. And then we get into what I feel are the strongest arguments for the constitutional violation, that being that the restrictions were not drafted as narrowly as possible. The United States Constitution places the burden on defendant De Blasio to set forth specific facts demonstrating that his suspension of the First Amendment in the city is necessary to serve a compelling state interest and that the restriction is narrowly drawn to achieve that interest. Defendant De Blasio cannot meet this burden here. Pursuant to clearly established First Amendment jurisprudence, the loss of First Amendment freedoms for even minimal periods of time unquestionably constitutes irreparable injury sufficient to warrant injunctive relief. In the final analysis, the First Amendment restriction as set forth in this complaint has no real or substantial relation to its claimed objective, and it is beyond all question a plain, palpable invasion of rights secured by fundamental law. Consequently, it is the duty of this court to so adjudge, and thereby give effect to the United States Constitution by declaring the First Amendment restriction unlawful and enjoining its enforcement. Then we get the prayer for relief, and no, it's not an actual prayer, it is just the conclusions being sought. Wherefore, plaintiff asks this court, A, to declare that defendants violated the First and 14th Amendments to the United States Constitution as set forth in this complaint. B, to declare that the First Amendment restriction violates the First and 14th Amendments to the United States Constitution as set forth in this complaint. C, to preliminarily and permanently enjoin defendants' First Amendment restrictions as set forth in this complaint. D, to award plaintiff nominal nominal damages for the past loss of her constitutional rights as set forth in this complaint. E. To award plaintiff her reasonable attorney's fees, costs, and expenses pursuant to 42 U.S.C. 1988 and other applicable law. And F. To grant such other and further relief as this court should find just and proper. And regardless of how you may feel about Pamela Geller personally, it is important that people like her file these lawsuits. The argument is simple and it is obvious, which makes it very powerful. De Blasio, through these executive orders, has issued sweeping restrictions on fundamental rights and liberties. If there are going to be any violation to constitutional rights, there had better be a darn good justification. Not only does there need to be a darn good justification, but the restrictions have to be as narrowly drafted as possible. From the allegations of this lawsuit, the executive orders are issuing sweeping restrictions on constitutional rights. And they are doing this in a manner that is totally contradicted by other policies that they have in effect. The argument is that de Blasio is restricting constitutional rights while allowing these streets to be open to pedestrians and cyclists. And so the argument is that you can't restrict certain fundamental constitutional rights while allowing other type of behavior that totally defeats the purpose for which you are violating those constitutional rights. But I don't think the weakness of this lawsuit lies in the law. I think it lies in the social pressure that any judge is going to feel to render a decision to invalidate those executive orders. It is going to take one brave judge to say, I am declaring these executive orders unconstitutional even if all of society blames me for the risks that it might be creating. The problem here is not one in law, it is one in the social pressure that any judge who is going to be called on to render a decision is going to be feeling. Few judges are going to want to be the judge who declares unconstitutional an order that was only there to protect the public. The response to that concern, however, would be that it's not because a judge declares the executive order unconstitutional that all hell is going to break loose. A judge could declare the executive order unconstitutional but leave it in force while the government goes and drafts a constitutionally acceptable executive order. So despite the fear, it's not in fact the case that it's all or nothing. If you declare this executive order unconstitutional, people are going to flood the streets. The judge could declare it unconstitutional and give a certain period of time to the government to go ahead and draft an executive order that is constitutionally acceptable. But the media being what it is and headlines being drafted the way they are, we know how the media would depict any judge who declares this executive order unconstitutional. That is not the legal reality, that is the social reality. Alright, and with that said, I think I better get back into the house because I think I can hear kids screaming through the house and through the car. If you like my videos and you like my content, please be sure to like, share, subscribe, hit the notification bell, drop a comment in the comment section below. It feeds the algorithm. If you want to support the channel, all of these support links are in the pinned comment. We've got some good merch. It's fun stuff. It's, nice to support a channel if you want to do that. Make your predictions as to where you think this is going to go. I am not optimistic, but I would love to be proven wrong. Stay safe, stay healthy, stay sane, get some exercise, get some sunlight, and now you know your vlog. Peace out. Booyah!